Hello, everyone. So we are here to go through Wayfarer's reply to Lively's opposition to their motion for judgment on the proceedings. Before I start, though, I just kind of want to say I think my videos are being suppressed by YouTube. I know a few people that this is happening to. Ashley, Brianna, Eve is one of them. I don't know this for sure, but I've had a lot of people saying that it's been incredibly hard to find the videos, even if they put the full title in. They're finding it really hard to find my videos, and my numbers appear to have been kind of a lot lower than they would normally be, which has been a surprise, because my subscriber count is going up. So I just, out of an abundance of caution, really, I'm going to be doing posts with the links to say, oh, here's the video, and then kind of link the video, because I don't know what else to do. I do also post links to the videos on X as well. So if anyone's on X, you can keep an eye out for videos there if YouTube's not notifying you. But also check you are subscribed, because I've heard of people being, finding out later on that they're unsubscribed, but that wasn't an action they took. I'd also recommend as well clicking the notifications bell, because that should notify you then when I upload a new video. But if you are having any problems finding my stuff, please let me know, because I'm going to keep looking into it. But it'd be interesting to see, if other people are having this issue. Okay. So this is not too long of a document, actually. It's only 15 pages, and as per, the first few pages are the index and the case. Sorry, the case, the table of authorities is what you call it. Okay, so already 5 pages in now, so really there's only 10 pages of this. Okay, now just to kind of recap, the motion for judgment on the pleadings, I was incredibly impressed with what Wayfarer wrote. Lively's response made some decent points, but I wanted to see how she responded. Some of it was all right. Some of it I thought, yeah, that really doesn't defeat the argument for me that Wayfarer put forward in the first place. So this is Wayfarer now responding to that. Let's see what they say. Okay. Lively's opposition hinges largely on extrinsic evidence, including all arguments and evidence submitted in support of her opposition to defendant's summary judgment motion, an implicit admission that, as pleaded, her claims are deficient. Lively, however, provides no authority that might permit the wholesale incorporation of facts and argument that purportedly would have supported her claims had they only been pleaded. Just to remind everyone as well, the difference, one of the biggest differences between the summary judgment motion and the judgment on the pleadings is judgment on the pleadings is law only. So it's like motion to dismiss. But instead of a motion to dismiss being something that your opposing party would put forward in response to your complaint, motion for judgment on the pleadings is kind of reversed, if this makes sense. So Wayfarer are not being asked, they're not asking to be dismissed. They're saying to Judge Lyman, can you please look at this and make a judgment on the pleadings. So that could see some of the claims dismissed, all of the claims dismissed, none of the claims dismissed. It's very, very similar to a motion to dismiss. But also, like a motion to dismiss, it is based on the four corners of the, what's there, and it is law. It does not include issues that are fact-based. Motion for summary judgment, however, is both law and fact. So lineman can look at evidence. And the fact that it includes evidence is I'm being snarky here, but half-heartedly, also being quite honest. That may be why Lively didn't file one, because there's no evidence to put forward to Judge Lyman to say, hey, Judge Lyman, can you grant me a summary judgment? Just a thought. So this document, so the summary judgment we looked at earlier, that's going to be based on law and fact. This document is just law only. Okay, let's continue. Lively not only fails to show how or why the court should stray from the rule that in considering a motion for judgment on the pleadings, the court is confined to allegations on the face of the pleadings. And that's what I meant by the four corners. The court is confined to allegations on the face of the pleadings, so you can't go beyond what her complaint alleges. Documents integral to the complaint and matters judicially noticeable, she fails to show that the new evidence she proffers would provide material support for her claims and cure the deficiencies in her pleading. Specifically, and among other things, the new evidence Lively advances falls far short of establishing the nexus between California and defendants' allegedly wrongful conduct sufficient to overcome California's presumption against extraterritorial application of FEHA and Labor Code 1102.5. Oh. Right, I'm not sure what I pressed there. Okay. Plaintiff does not even try to substantively respond to her failure to plead an adverse employment action, a critical element of her retaliation claims, but merely refers the court to her summary judgment filings, which are similarly cited to support her defamation claims. This is a pleading motion directed to deficiencies in the complaint. By relying on extrinsic evidence first submitted in connection with a summary judgment motion, Lively concedes that her complaint, standing alone, is insufficient to plead her claims. Succinctly put, deficiencies in a complaint cannot be retroactively cured by evidence submitted in a summary judgment opposition or merely proffered in opposition to a Rule 12c motion. Plaintiff's opposition relies on facts and evidence extrinsic to the complaint. A motion for judgment on the pleadings tests the sufficiency of a pleading. When deciding a motion on the pleadings, the court must confine its consideration to the pleadings and their attachments to documents incorporated in the complaint by reference and to matters of which judicial notice may be taken. Implicitly conceding that, as pleaded, her claims cannot withstand a motion to dismiss, plaintiff offers several options for the court to consider extrinsic facts, including 1. The wholesale incorporation of arguments and evidence submitted in connection with her summary judgment opposition. 2. Conversion of defendant's motion for judgment on the pleadings to a motion for summary judgment. And or 3. An amendment to conform the complaint to proof. The court should decline plaintiff's invitation to depart from the rules applicable to the motion to dismiss. Plaintiff first fails to cite authority for the notion that all arguments and facts set forth in her summary judgment opposition can be incorporated into her opposition to a Rule 12c motion to dismiss. To the contrary, a party may not incorporate by reference an argument in a summary judgment motion into a motion for judgment on the pleadings. Plaintiff punts to Rule 15b(2), which provides that when an issue not raised by the pleadings is tried by the parties' expressed or implied consent, it must be treated in all respects as if raised in the pleadings. The rule further provides that a party may move at any time, even after judgment, to amend the pleadings to conform them to the evidence and to raise an unpleaded issue. Thus, although it is often said that one may not amend one's complaint via an opposition to a summary judgment motion, Rule 15b(2) provides that issues not raised in the pleadings are treated in all aspects as if raised in the pleadings if they have been tried by the parties' express or implied consent. Accordingly, Rule 15b amendments to conform to proof have been permitted to add new claims or legal theories in the context of a summary judgment motion, where a fact or evidence has been placed at issue and thus raised with the parties' consent. Rule 15b does not apply to this motion for judgment on the pleadings. Defendants did not raise Lively's new evidence, or indeed any evidence, in its Rule 12c motion, which focuses solely on the legal deficiencies in the complaint. And of course, the facts have not been tried at trial or at an evidentiary hearing. Thus, defendants have not consented to try the new facts or evidence proffered by Lively. Finally, defendants did not raise the issue of extraterritoriality in the summary judgment motion and therefore did not try the issue by consent, even assuming consent to the admission of extrinsic evidence on a motion to dismiss can be created by presenting evidence in support of a summary judgment motion. Defendants do not dispute that Rule 15b allows a party to move at any time, even after judgment, to amend the pleadings to conform to the evidence. Plaintiff has not moved to amend her pleadings, even though defendant's motion was filed on September 26, 2025, giving plaintiff ample time to seek a proper amendment, affording defendants the opportunity to oppose an amendment to add new facts. Notably, where a complaint is dismissed without leave to amend for failure to state a claim, evidence that might support a claim on summary judgment is rendered irrelevant and, in fact, will never be presented, as the matter will not proceed to the summary judgment stage. As noted, Lively offers no authority for the notion that a summary judgment motion can retroactively amend a complaint to salvage claims that were not sufficiently stated in the first place. Nor can defendant's Rule 12c motion be converted to a summary judgment motion. If on a motion under Rule 12b(6) or 12c, matters outside the pleadings are presented to and not excluded by the court, the motion must be treated as one for summary judgment under Rule 56, and all parties must be given a reasonable opportunity to present all material that is pertinent to the motion. Plaintiff suggests that because defendants presented evidence relating to an adverse employment action in their summary judgment motion, the court should convert the motion for judgment on the pleadings. Conversion, however, is appropriate when a moving party bases its motion to dismiss on extrinsic evidence. Defendants have not cited any extrinsic evidence in support of its motion for judgment on the pleadings, and plaintiff does not cite any decision in which a court has converted a motion to dismiss to a summary judgment motion because plaintiff opposed with extrinsic evidence. Any such rule would obliterate the distinction between motions to dismiss for failure to state a claim and summary judgment. Plaintiff concedes that the complaint fails to allege an adverse employment action under FEHA or Title VII. Plaintiff does not even bother to address her failure to plead an adverse employment action as required for retaliation under FEHA or Title VII. Plaintiff only glancingly refers to an adverse employment action in her introduction, stating in the most conclusory fashion that she more than adequately pled an adverse employment action and causal links. Failure to oppose an issue raised in a motion to dismiss effectively concedes the issue. Plaintiff merely directs the court to the arguments and evidence submitted in her summary judgment opposition. As explained above, a party cannot effectively oppose a legal argument framed in defendant's motion to dismiss by simply incorporating by reference an argument asserted in her opposition to defendant's summary judgment motion, and doing so cannot retroactively cure a failure to state a claim in the first place. In fact, the only plausible explanation for this critical omission is that plaintiff seeks to evade the court's 25-page limit for her opposition. Incorporation by reference is not a proper device to avoid the page limits. Since plaintiff concedes that she failed to plead an adverse employment action, her retaliation claims under FEHA and Title VII should be dismissed. It's a good argument. Okay. Plaintiff fails to overcome California's presumption against extraterritoriality. In a particularly muddled argument, plaintiff argues that a choice of law provision in plaintiff's unexecuted loan-out agreement abrogates California's firmly established presumption against the extraterritorial application FEHA. Implicitly acknowledging the frailty of this argument, plaintiff falls back on facts extrinsic to the complaint. To establish a nexus between California and the material elements of her FEHA discrimination and retaliations claims. These arguments not only fly in the face of firmly established California law, but contradict plaintiff's own pleading. To salvage her claims under FEHA, plaintiff engages in a tortured choice of law analysis to argue that California's presumption against extraterritoriality does not apply, even though Lively is not a California resident, and her own pleading establishes that the allegedly offending conduct occurred outside California in New York and on the New Jersey set of It Ends With Us. Lively suggests that a choice of law provision in Lively's unexecuted actors loan-out agreement somehow supplants the rule governing extraterritoriality, and that FEHA does not include a geographical limitation. The parties could not contract around the extraterritoriality constraints of California's statutes, even if they wanted to. A contractual choice of law provision cannot determine whether a given statute is to be given extraterritorial effect, because that question requires a court to focus on legislative intent rather than on the party's intentions as expressed in a contract. Okay. It is well settled that extraterritoriality is a matter of statutory construction, and parties cannot create by contract a cause of action that California law does not provide. Contrary to Lively's allegation, FEHA contains clear geographical limitations. The California legislators' findings and declarations of policy provide that FEHA protect the public welfare, prosperity, health, and peace of the people of the state of California. In 1984, the legislature reiterated its intent to restrict FEHA's scope. The legislature finds and declares that it is the existing policy of the state of California to prohibit harassment and discrimination in employment on the basis of any protected classification. Such conduct, whether intentional or unintentional, is a violation of the civil rights of California citizenry. FEHA itself states this part shall be deemed an exercise of the police power of the state for the protection of the welfare, health, and peace of the people of the state. When a law contains geographical limitations on its application, courts will not apply it. Parties failing outside those limitations, even if the parties stipulate that the law should apply. Thus, as the California Supreme Court explained over a century ago, basing the geographic reach of California statutes on the circumstances of a private contract is not tenable, and extraterritoriality resolves itself then into one of the correct interpretation of a statute. These are really good arguments. Choice of law provisions come into play only if the legislator has determined the statute can apply in a given context. In other words, they reflect the party's choice among the collection of laws that could apply. They do not add new and different laws to that basket of options. Moreover, a contractual choice of law provision that incorporates California law presumably incorporates all of California law, including California's presumption against extraterritorial application of its law. And because a California choice of law provision embeds California's presumption against extraterritoriality and consequent implicit geographical limitation, it cannot be used to circumvent those very principles. In short, the ALA's choice of law provision does not abrogate the well-established principle that the presumption against extraterritoriality applies to FEHA. To overcome the presumption, Lively must plead a specific factual nexus between the defendant's California activities and the majority of allegedly discriminatory conduct. Okay. Cases in which a factual nexus was found are not comparable. For instance, in Doe, the court found a factual nexus where the complaint alleged that a plaintiff met with and was hired for by an offshore photo shoot by a California defendant who knew, based on the photographer's histories, that the photo shoot was an opportunity for sexual assault. Lively admittedly did not plead the required nexus and instead urges the court to consider new facts that purportedly create the necessary link, and the new facts, they've said new facts twice. And the new facts proffered by Lively are insufficient to establish the requisite factual nexus. Lively points to a pre-production statement by Jamie Heath, presumably in California, hoping for a successful birthing of the film project. It stains the credulity to argue that using the term birthing as a substitute for creating was sexual or harassing in nature. Completely agree with that. More importantly, there is no allegation or evidence that Heath or any Wayfarer party knew or had reason to anticipate discriminatory conduct. In this vein, Lively notes pre-production communications relating a HR department and Wayfarer's decision not to have a full-blown HR department for the film. According to Lively, such decisions purportedly made in California set the tone for harassment. Whatever that means, a decision on the scope of HR services without any link to a motive to promote harassment or somehow avoid future liability for harassment is not sufficient to plead a causal link between California and discriminatory conduct which allegedly occurred on the film's set. Film in spring of 2023. This could have been word-proofed a little bit better. Lively also points to complaints by Lively to Sony about conduct on the set. Sony was not Lively's employer. Sony is not affiliated with Wayfarer, and, as Sony told Lively, was not a proper party to receive her complaints. Sony referred Lively to the Wayfarer principals in New York. Even assuming the court were to consider these extrinsic facts, they are insufficient to plead a nexus between the allegedly wrongful conduct on the film's set and California. As for Lively's retaliation claim, Lively contends that it was created and launched by crisis manager Melissa Nathan, public relations representative Jen Abel, and Jed Wallace. While Nathan and Abel may have been in California, they are not Wayfarer employees, were not involved in the allegedly wrongful conduct, and cannot be liable for retaliation wherever it occurred. Okay. Lively fails to show that her defamation claims are adequately pleaded. Lively again relies primarily on extrinsic evidence presented in her summary judgment opposition to refute defendants' arguments on the deficiency of her defamation claims. First, relying solely on citations in her summary judgment opposition, Lively contends that defendants' opinion defense is meritless. However, the only defamatory statements identified by Lively are Mr. Friedman's statements to the press on his opinion on the merits of Lively's claim and conduct in the litigation. Lively argues that New York and California's litigation privileges do not apply to the statements to the press. Lively cites Rothman for the proposition that California's litigation privilege does not apply to litigating in the press. There, the lawyer defendant accused another lawyer of making public statements to extort a settlement from Michael Jackson. Mr. Friedman's statements, in contrast, were made after Lively filed her complaint in December 2024 and expressed his opinion on the merits of her claims. Unlike the lawyer in Rothman, Mr. Friedman is not a defendant, and plaintiff fails to show why his public statements are a proper basis for a defamation claim against the defendants. Lively next argues that New York's fair report privilege does not apply because the defamatory statements constitute litigating in the press and do not reflect reports of any judicial proceeding. Lively again turns to her opposition to defendants' summary judgment motion, pointing to statements which she alleges were not made to report on judicial proceedings. However, the statements by counsel, to the extent they can even be construed as defamatory, which they are not, merely repeat defendants' assertions made in court and fall within the scope of protected speech under Section 74. Okay. Lively's joint employer argument is misplaced. Lively devotes 2 pages to an argument that defendants did not make. Namely, that Wayfarer should not be dismissed because although Wayfarer was a joint employer with Ainsworth's movie, liable under FEHA and Title 7. Okay. In a footnote, defendants merely note that Lively blurs the lines between Wayfarer and It Ends With Us movie, Lively's employer. Even if defendants made this mythical argument, they're not mincing their words, are they? Even if defendants made this mythical argument, Lively's joint employer theory was not adequately pled, as there are no allegations that Wayfarer paid Lively's salary, hired her, or had any control over her daily employment activities. Common ownership, supplying administrative support, and shared HR policies fall short of the level of control the joint employer doctrine demands. Okay. Conclusion: for the foregoing reasons and those set forth in defendants' motion for judgment on the pleadings, defendants respectfully request that the court enter an order granting this motion and dismissing plaintiff's claims with prejudice. Okay. That was Ellen. So that was really well written, actually. But, it should have been proofread, I think, a little better. But I love the arguments. I love the snark. I'm always here for the snark. I've had some people say that Not Actually Golden has done a video on the if we remember, Lively claims to have updated her CRD complaint to include It Ends With Us movie, because one of the things that Wayfarer raised was the fact that It Ends With Us movie, the actual employer, was not on the original CRD and therefore not covered by the original right to sue letter. So Lively responded and said, no, I updated it. And I think her opposition basically in her response, she said that the original right to sue letter was still in force. Now, I haven't seen Not Actually Golden's video. I have not got round to it yet. I will. But I've had a lot of people say to me, is that right? Can the CRD then update the case? The case is already closed. So when the right to sue letter was issued, Lively did not want an investigation. She wanted the immediate right to sue letter, which she got, which effectively closed the case. I did actually go and have a look on what would happen if the CRD was then amended in the case that, in this case, involving a closed case. So, this is the California Code Regs, which deals with the CRD. This is the amending complaints. So, Section A, the department may amend an open complaint of discrimination. Section B, when an open complaint of discrimination has been amended. So obviously those first two sections do not apply. Then you look at Section C. The department shall not amend an open complaint. Right? Okay, so again, we are still talking about open complaints, right? Okay. Section D. The department shall amend closed employment discrimination complaints as requested by complainants or their counsels, right? So they do amend them, and that's fine. Section E, when the department amends a closed complaint, the department shall neither reopen the complaint nor make an administrative determination on the validity, retroactivity, or merits of the amendment, right? So they don't reopen it to make any determination. So then you go to section F. When a closed complaint is amended by the department, the original filing date and right to sue letter shall remain in effect, as shall the original statute of limitations for filing a private lawsuit. So that section, and again, not actually Golden would probably be the better person to sort of weigh in on this. I think Little Girl Attorney is the California lawyer. I haven't watched anything by her yet either, so I will check that out. But reading this and reading the language of this, when a closed complaint is amended by the department, the original filing date and right to sue notice shall remain in effect. It does not say that it is updating the right to sue letter. It says in fact, it actually expressly says that the original right to sue letter shall remain in effect. So that does not add It Ends With Us movie, in my opinion, onto the right to sue letter. I haven't seen the right to sue letter actually. Like in the exhibits, I haven't seen this amended right to sue letter. We've only ever seen the original one. But the language of this statute does not suggest that even if Lively did go back to amend it, that the CRD has done anything, has taken any action which would, bring It Ends With Us movie into this. I don't know. That's how I'm interpreting this. Maybe Little Girl Tony has a different take, and I always, I'm well aware of my limitations. I'm from the UK. I studied UK law. So, I always will defer to the US lawyers when we are talking about US law. But just reading the language of this law around specifically that situation, like, if she had amended her, by this point, closed CRD complaint to add It Ends With Us movie, then nothing changes. They don't issue anything new to acknowledge that change. So then it becomes like a big question mark then. Well, does she now have a right to sue Ends With Us movie? And the language of this law, to me, sounds like she doesn't. But I will, I will obviously defer to anyone else, US, particularly California, who says otherwise. So if she can't get around this, if Blake Lively can't get around this, then she does not have FIHA claims against It Ends With Us movie. So and that's my perspective on it, just to answer question. I've had quite a few people actually drop me a message or leave a comment and ask about this. So that's my viewpoint on it. I may be wrong though, so I don't know. If not actually Golden or Little Girl Attorney say the same, then I'm happy. If they say something completely different, then listen to them. Okay, I hope that answers that for you. All right, guys. Have a really good day, and please don't forget to like and subscribe.